economic immigration is uncertain. There's program changes. The numbers of people who are allowed to come through that pathway are shrinking. And, it's getting harder and harder to make a refugee claim. So for a lot of people, will sponsorship be an option? And the good news is that, of course, love is love. That's a very solid foundation for an application. And IRCC, the Immigration Department, is still processing those. The only thing that could change is that processing times could get a little bit longer. But for now, the spousal sponsorships are definitely moving forward. So if that's something that you're considering, you don't have to worry about what the changes that are constantly happening mean for this program. So like I said, my name is Karen, and I've been doing immigration law for the last number of years. I graduated from law school at University of British Columbia, and my entire time as a lawyer has just been doing immigration and refugee matters. Sponsorship is something that is very important to me because I actually was not born in Canada. I came here as an international student, and then I ended up getting my permanent residence through sponsorship. But back then, I did not know anything about the law, and I ended up making some mistakes, and it took a lot longer than it should have, and was a very stressful time. So I'm very glad that I now have a lot of knowledge and experience about that program, and I hope to be able to help people avoid that same situation. So just an overview of what I'm hoping to cover is, first of all, who can sponsor and what the eligibility requirements are for that person. And then additionally, who qualifies as the person being sponsored, the principal applicant. And then I'll go through the different type of sponsorship applications that there are, as well as what legal tests need to be approved. And then the process, which includes what documents you need and what forms there are, as well as whether you can apply for a work permit while you wait. And then finally, what some difficult situations could be that arise for people. So also, just to preface this, I want to say that this is the general context. Since immigration is federal, the sponsorship program applies to people anywhere in Canada. But in Quebec, the immigration program is slightly different, and I'm not going to be talking about that. I'm just going to be covering the general program for people who are outside of Quebec. So in order to sponsor, you need to be at least 18 years old, and you need to be either a citizen of Canada, a permanent resident, or registered under the Canadian Indian Act. And as part of what's required in the application, you're going to have to submit a copy of your passport, your Canadian birth certificate, or your citizenship certificate to prove that you meet this requirement. And then you also need to either be living in Canada or prove that you will live in Canada once the application is processed. An important thing to know is that you can only apply if you're while you're outside of Canada, if you are a Canadian citizen. If you're only a permanent resident, you have to be living in Canada at the time you submit the application in order to sponsor your spouse. And if you are a citizen who's outside of Canada, planning to live in Canada with your spouse when the sponsorship goes through, there's no specific requirement or way to prove that, but there's a variety of things that you could do depending on your situation. For example, it could be things like proof that you're pursuing employment in Canada, or proof that you have a rental agreement or own property that you'll be living in. It could even be things like letters of support from Canadian relatives attesting to your intention to return, proof that you're, hiring movers for an international move, or, having a detailed relocation strategy about when you plan to arrive and financial planning and things like that. There are some prohibitions to being a sponsor. And one of the things that immigration really cares about is finances, making sure that you can support the spouse that you're sponsoring and that they won't rely on income assistance when they come to Canada. And so because of that, a key part of the sponsorship application is the undertaking that you as the sponsor will sign. And that is just a commitment or basically a contract with the federal government that you will provide financial support for the applicant's basic needs. So things like food and clothing and shelter. And that undertaking that you sign is a period of 3 years after the application is approved, if it's for a spouse. And if the spouse that you're sponsoring has children who are dependents as well, then that undertaking applies to them for the period of time that's either 10 years or when they turn 22, whatever happens soonest. So you'll need to be able to show that you're not receiving income assistance unless it's disability benefits. And you need to show that you can provide for the basic needs, not only for yourself, but also for your spouse and any dependent children that they have. So the important thing is if you're sponsoring just a spouse, there's no actual minimum income threshold that you have to prove. You just have to show that you can support them. So basically, if you can show that you have a source of income, that should be sufficient, and they're not going to look further into, well, do you meet a certain level? But if you are sponsoring a spouse who has dependent children, then you do have to meet a certain income requirement. And that varies depending on family size, and it kind of changes every year. And then basically the crux of that undertaking is if the person you're sponsoring does go on income assistance during the period that that undertaking is in place, then you will be responsible for paying that amount back to the government. And if you don't, then you'll be considered to be in default of that undertaking. And so based on all of that, one of the things that will make you ineligible to sponsor is if you previously had signed an undertaking and you're in default of that. Or additionally, if you previously sponsored someone and that undertaking period is still valid, meaning it's been less than 3 years, that could also impact your ability to sponsor. Another prohibition is if you are in default on an immigration loan, or if you haven't paid court-ordered child support or spousal support, or other situations like that. And anything that you're in default of, whether that's income assistance or family court payments or some sort of debt or loan, all of that will have to be resolved or repaid before you will become eligible to be a sponsor. And another thing to note about that undertaking is if your sponsorship application is approved, that undertaking remains in effect for that 3-year period, even if your situation changes, even if you get divorced or something like that, there's no way to get out of that undertaking once you've signed it. Another bar, a potential bar could be if you've declared bankruptcy and that hasn't been discharged. Another one can be if you yourself as a sponsor had previously been sponsored as a spouse by someone else and you got your permanent residence through that less than 5 years ago. And that applies even if you've become a citizen, but that 5-year period hasn't elapsed yet. And finally, there are some eligibility bars if you've been convicted of certain criminal offenses, including an offense of a sexual nature, a violent crime, an offense against a relative that caused bodily harm, or threats or attempts to commit any of those things. The next thing, then, we've covered eligibility for being the sponsor. So now, who can you sponsor? You need to meet the definition from the Immigration Department to be a spouse, both at the time of filing and throughout the duration of your application. So that means if you're planning to get married in 2 months, you can't file now. You have to wait until you meet the definition. And if the application, you submitted it, it's still in process, but now things changed and you're separating from your spouse, you have an obligation to update IRCC about any changes to your situation, including changes to your marital status. And that will likely mean that the spousal sponsorship can't proceed because you're no longer eligible. So one option of spouse that you can sponsor is someone you're married to. The marriage needs to be legally valid. So whether that's in Canada or outside of Canada, it will need to be legally recognized there and in Canada. And IRCC does not recognize marriages where both people were not physically present at the ceremony. So if it was over the phone or by proxy, that won't be considered legally valid. And Canada also won't recognize a marriage as legally valid if one of the parties previously was married but didn't legally get a divorce because you can't be married until you're divorced. And there could also be some issues around things like age of consent or other legal impediments. So if you're not married or if that's not an option, you can also sponsor a spouse who's common law with you. And so for the sake of immigration, they define common law as living together with your partner in a marriage-like relationship for at least 1 year. And so obviously there's a little bit of flexibility in that in the sense of, maybe your partner has to travel for work or for a family obligation or something like that. That's okay, but any time spent away from each other should be short and temporary. And finally, there's a third category that's quite rare, very, very rare, and that's called conjugal partner. And that is only applicable to someone your partner who's outside of Canada. They can't be in Canada and qualify for that category. And for this, you need to prove that you've been in an exclusive and mutually interdependent relationship with that partner for at least 1 year, but that there's some impediment, like you can't live together for whatever reason and you can't get married. So it could be things like religious or cultural barriers or legal barriers. For example, if so, in some places, same-sex relationships are illegal, so there's no way that you could get married or even have a common law relationship, but you could maybe still be a conjugal partner. Or, if you would face persecution for an interreligious marriage or something like that. But again, it's very rare. So moving on, then there's two different types of spousal sponsorships. One of them is called family class, and the other is called the in Canada class. And so to start with a family class, that option can be used by an applicant who's either inside Canada or outside Canada. If you're in Canada, sometimes people don't necessarily stay. Maybe they have to go back and forth for work or other reasons. And so if you're traveling a lot or still finishing a job somewhere, even if you have valid temporary status in Canada, it could be best to use the family class option so that there's not questions raised about whether you're eligible to apply from inside Canada. An important advantage of a family class application is appeal rights. If your application under this class is refused, you have an automatic right to appeal to a tribunal that's called the Immigration Appeal Division. Unless there's very few situations where you're not eligible, depending on if the person has been found inadmissible. And for that type of appeal, you have a deadline of 30 days after you get a refusal to file the appeal. And if the appeal is granted, the outcome is that IRCC will resume processing on the application, taking into consideration the guidance from the tribunal. I mentioned earlier that a conjugal partner is someone who has to be outside Canada, so this would be the only option that they have would be a family class type application. And an important distinction between the family class and in Canada class is processing times. On the website for IRCC, they publish their standard processing times. They're always changing. So right now, the family class sponsorships are listed as 15 months for people who are being sponsored intending to live outside of Quebec. In contrast, for the in Canada class, you have to be living in Canada, and you either have to have valid status or there's a special public policy that allows some people who don't have valid status to still qualify for sponsorship under this. If you are inadmissible or non-compliant with immigration laws because you maybe came here as a student or a worker or a visitor, but then you didn't extend your status or it was refused, and so you've overstayed your status, that's one option where you would still probably qualify under this public policy. Another is if you worked or studied without having authorization to do so, or if you entered Canada without a valid passport or without the proper visa, you could still be eligible under this. If you are inadmissible for any other reason, like for example, if you got deported from Canada and then you came back without getting permission, or if you had a failed refugee claim, so you have a removal order due to that, those are the kind of situations that aren't captured under this public policy, and that means that your situation would be much more complicated. In the in Canada class, you don't have the same appeal rights to the tribunal. Your only option to challenge a refusal is at the federal court, and that process is much more difficult. You're much more limited. You're not allowed to submit new evidence for the most part, and there's no guarantee that your case will move forward because the federal court doesn't have the resources to move forward with every case that comes before them. And it's also a much tighter timeline. You only have 15 days to apply to challenge the refusal. And in contrast to the 15-month processing time for the family class, right now IRCC lists the processing time for in-Canada applications as being 21 months for people intending to reside anywhere except Quebec. So if you know that you're eligible and you know that the person you're sponsoring is eligible and you know which type of application you'd like to move forward with, then we can move into what's required for that application and how that process works. So the important thing to keep in mind is that the legal test that you need to meet for a sponsorship application is that you need to prove that you're in a genuine relationship with your partner and that the relationship was not entered into for the sake of immigration. That comes from our immigration regulations. There's a section that specifically says those are the things. You won't be considered a spouse if those aren't met. And so regarding the genuine relationship, it can be red flags for an officer in a variety of situations, perhaps things like if it seems like you and your partner have nothing in common, if there's, a huge age gap between you, if there's a language barrier, which makes them question how you even communicate with each other, if you don't really have much history together, some things like that. And then regarding the purpose of immigration, there can be red flags for situations such as if you're about to get deported and then all of a sudden you get married or something like that that looks like it could just be a matter of convenience instead of love. Obviously, there are situations where those can be very genuine and those can be based in love and still have suspicious facts. So that's when it's important to make sure your application makes your situation very clear and has as much supporting evidence as possible so that you can convince the officer of those things. And if the officers has doubts, they can ask both the sponsor and the applicant to come for an interview. They can interview you separately, and it can be a very intense process where they're trying to determine those things. So it's best if you can avoid that by having the strongest application possible. When you apply, you have to submit a lot of information in the variety of forms that IRCC requires, as well as documents that they require as evidence and to support your identity and your relationship and things like that. And so most applications have to be submitted online, and some of those forms are automatically filled out online. You just put the information in and they'll be good to go. And so those specific for the applicant, there's a form where they ask for, basic background information, things like address history and employment history and education history and stuff like that. And for family information, they're going to ask about parents and siblings and children and previous relationships and things like that. And depending where you're from, there can be specific requirements from that country that don't apply to like all people. So IRCC has those listed on their website. And then there's also the undertaking that the sponsor will have to fill out, which I explained earlier. And that form will also ask questions about the sponsor's status, previous relationships, and those eligibility criteria that we talked about. And then both the sponsor and the applicant will have to fill out a form that goes into their relationship history. And the sponsor will also have to provide information about their employment history and education and address history and things like that. And it also is going to ask about details like the first time you met and contact you had before that, visits you made to each other if you're not living together, your regular forms of communication, if you're married, details like your engagement and wedding and things like that. And all applicants are required to pay IRCC processing fees. And so there's an $85 sponsorship fee, there's a $545 processing fee, there's a $575 right of permanent residence fee. And if the person you're sponsoring has dependent children, each child will be $175. And it's also possible that the applicant will have to pay an $85 biometrics fee as well. And so then to go along with all the information that's provided in the forms, the sponsor is going to have to provide proof of their income. So that can be like a letter from their employer, and a notice of assessment from the most recent tax form that they filed with the Canadian Revenue Agency. The applicant is also going to have to provide their passport and birth certificate and identity documents like that. They're going to have to provide proof of their status in Canada. So that could be, a visitor record or work permit or whatever they have. If either the sponsor or the applicant was previously married, they're going to have to provide proof of the divorce and things like that. And the applicant is going to have to provide police certificates from any country other than Canada where they spent more than 6 months consecutively since the age of 18. For some people, that's a pretty straightforward process, but if you've traveled a lot and worked in other places, that can get pretty complicated to try to get all of those. And the applicant is also going to have to provide a passport style photograph to go in the application, and they're going to use that to create documents, like if you eventually get a permanent resident card and things like that, and just to confirm, recently what you look like if it's a bit different than your ID documents. And then you're going to have to get a lot of documents together to prove the relationship between the sponsor and the applicant. So if you're married, you have to have the marriage certificate. And if you're not, then you need to provide a declaration about your common law relationship. You're also going to have to provide proof of visits or contact that you've had with each other. That can be, if you're not living together, that could be things like boarding passes from flights to visit each other, screenshots of video calls or messages. And if you are living together, then you're going to need things like proof that you jointly own property or proof of joint rental agreement. It can be government documents like driver's licenses that show the same address for both of you, or bills being sent to the same address for both of you, and proof of joint finances and things like that. So if you have a joint bank account, or if you're listing each other as beneficiaries for like benefits that you have or other accounts, things like that. If you filed taxes together, common law, that can be helpful. And you also need to provide some photographs that show the duration of your relationship, show that you've been together for a while in different settings and have captions to show that. And it's also really helpful if you have public recognition of your relationship. So maybe you've got social media accounts where you went public about being in a relationship or being engaged or something like that. And you can also get support letters from people who know the sponsor, people who know the applicant, people who know both, just confirming the genuineness of the relationship. That can also be really helpful. And it's important to know that for all documents that you're submitting for any immigration application, anything that isn't in English or French needs to be translated by a certified translator. Otherwise, the officer can't process it. Since the processing times are quite long, it's helpful to know that there are pathways for applicants who are waiting for their sponsorship to go through to apply for a work permit. So it used to be that only applicants who were using the In Canada class and were in Canada with valid status could apply for a work permit, but that's changed. Now there's a policy in place that allows family class applicants who have come to Canada to be able to apply as well. For both classes, in order to submit the work permit application, you're going to need to show that your sponsorship application has been submitted and has met the completeness check. So you'll get what's called an acknowledgement of receipt document that confirms it's in process. And with that acknowledgement of receipt document, when you submit your work permit application, they'll be able to connect it to that and you'll be eligible to apply. The unfortunate thing is work permits are also taking a long time to process. It could be around 8 months or so right now. So this is helpful, but it's also not that helpful given the long time you have to wait anyway. There are a lot of situations that aren't necessarily straightforward because no one's lives are straightforward and no one's relationships are straightforward. So there can be situations that are outside of the norm and that can make your processing take longer. That can mean you might have to take extra steps to even be able to submit the application. So I'm just going to cover a few of the more common complications that can arise for people. So one situation is if you were previously married, but your divorce hasn't been finalized yet, but you're living with a new common law partner, and you want to do a sponsorship, that doesn't mean that you can't until the divorce is finalized, because as I mentioned earlier, there are situations where you just simply can't get a divorce. That doesn't mean that you can never proceed with a sponsorship. It can be possible to move forward if, under the common law category, if you can prove that your divorce is in process, that the separation is final by both parties and has lasted for at least a year. And it gets complicated because you'll need as many supporting documents as possible as proof that that relationship is over, such as, documents that removed them from insurance policies or court orders about children if you share children with that person, or separation agreement or a signed declaration, things like that. Another complicated situation is where someone who you're sponsoring or someone in their family is inadmissible to Canada. And so there's various grounds of inadmissibility. It could be for criminality, it could be for misrepresentation, it could be for medical needs, security risks, things like that. So the complicated thing is that all family members must be declared and examined, even if they aren't coming to Canada. So that means if the person you're sponsoring has a child living overseas who's not coming with them, that child will still have to be examined, which means they'll still have to have their information disclosed to IRCC. They'll still have to have they'll have to get a medical exam, they'll have to have their background checked, things like that. And if for some reason that child is inadmissible, that inadmissibility can extend to everyone in the family, including the person you're trying to sponsor. And so if that's the case, then that inadmissibility, whether that's someone in the family or the sponsor themselves, is going to have to be resolved before the permanent residence can proceed. There's a variety of ways that you can try to do that with different types of applications, but those all take a very long time and are definitely something that you should speak to a lawyer about. Another situation is if I alluded to this earlier, you've got a sponsorship that's in process, but during that processing time, the relationship breaks down. And so, like I said, you have an obligation to update IRCC about that. And if you don't, then if you do get permanent residence as a result of that, you could be found later to be inadmissible to Canada due to misrepresentation for not updating that, since you technically would not have been eligible to get the permanent residence because you no longer meet the definition of spouse. There's a lot of situations, unfortunately, where family violence plays a big role in this. And if that's the case, IRCC has created special programs to help victims of family violence who are dependent on an abuser to keep their status in Canada. So there's a way to request that you shift the spousal sponsorship into a different type of application that's called a humanitarian and compassionate application instead, based on the abuse and other circumstances. It's also a very complicated process, so that's another scenario where I recommend that you speak with a lawyer to make sure you have the best chance of success possible. Another complication is a provision of the immigration law that's found at section 117 9D of the regulations. And that specifically says that you can't sponsor a spouse if they weren't declared in a previous application. So as I mentioned, IRCC needs to examine everyone, even if you're not coming. And that's the purpose of that is to make sure that you're not inadmissible to Canada. And so, for example, if you were 20 years old when your mom sponsored, who is Canadian, sponsored you for permanent residence, and at that time you were married, but you didn't disclose that to IRCC, then you come to Canada, you become a permanent resident. You can't turn around and sponsor your spouse because they weren't declared and they weren't examined previously. And so the issue with that is if they had been declared, you would not have been eligible to come to Canada yourself because you can't, if your parent is sponsoring you, you can't come if you're married yourself. So in that scenario, you can't sponsor your spouse because you shouldn't even have that option in the first place, according to the law, since you weren't eligible. There is an exception to this lifetime bar on sponsorship if you got your permanent residence as a refugee or protected person, or as a sponsored member of the family class. And if the applicant had been declared and examined when you got your permanent residence, that you wouldn't have been ineligible. So in the example I gave, doesn't meet that exception, but there are scenarios where it could. So again, if this is your situation, it's really complicated, please speak with a lawyer. And a final situation I want to highlight is sometimes the person you want to sponsor has children from a previous relationship, and they're planning to also have those children come to Canada. But it can be really complicated if the other parent of those children is not cooperating with you. Because if those children are going to be included in the application and come to Canada, then the other parent needs to provide consent or a signed travel authorization saying that they're okay with the children coming to Canada. And so that can be really difficult for people to obtain, and then that can stall the sponsorship application. And so again, that's a scenario where I recommend that you speak with a lawyer. I don't want to go on too much longer, so that's what I have for the substance, and I'm happy to move on to questions. And before I do that, I just want to say you can reach out to Titan Law about booking a free case review, which is basically a free screening process to determine if you meet requirements for immigration programs such as sponsorship. And through that, you can also get connected to a consultation with a lawyer if you need to. And that it's really important, especially if you have any of those complicating factors or if you have any of those scenarios that could raise red flags, that you get legal advice before you proceed or get a lawyer to help you with the application because it's very stressful, it's time consuming, and sometimes it seems like you only have one shot because of your situation. Maybe your partner's status is at risk here, or maybe there's complicating factors and you want to get them out of their country as soon as possible. And, if you have to go through an appeal process, it can get, much longer and more expensive. So getting it right the first time is always best. But if you have one of those sticky situations, all of the lawyers at Titan Law have a lot of experience with spousal sponsorships, simple and complex, and would be happy to help you out.